Wait, please, about.
Yes.
As I am seeking your lordship's indulgence to press a 389 for suspension of conviction.
Yes.
And let me give your lordship the 6 broad heads on which I seek that. Then I'll take them as point by point on those 6 broad heads. Well, as I respectfully seek a stay of suspension, a stay of conviction or a
Yes.
suspension of conviction. Firstly, because Balas, on the very tests propounded in as many as 6-7 pages in the beginning of the sessions court judgment under appeal, under revision, the offense involved here is admittedly, and I use the word admittedly, on the basis of the 6 pages of judgments extracted by the learned sessions court, neither of a serious nature nor of moral turpitude, which are the 2 tests your lordship applies to deny, if at all, in an relevant case, the suspension of conviction. So that is going to be the first head, which I will show to your lordships. The second head, Balas, is to take the allegedly offending sentence or words and show that they do not relate to or invoke or inculpate any identifiable, suable class of persons. Well, if you make a statement like this, you cannot have anybody out of allegedly, not as per us, as per the complainant, 13 crore people, anyone can be a complainant. That is not the law. There is no such identifiable, suable class to at all maintain a complaint. So jurisdictionally, the complaint would not be maintainable is going to be my second set of submissions.
But that will decide in the appeal.
No, these are all under 389.
389 only we have to see the suspension, why the court has not suspended this.
Correct. Now, one of the tests of your lordships for suspension, one of the tests of your lordship for suspension is that a prima facie case, a very strong case.
Appeal is pending before the consent trial.
Well, that will always be the case in 389. Correct.
Yes.
So your
Now
lordship.
only 389 is, and against that order you are preparing the revision application.
My lord is right.
So we have to see just 389 only.
Well, only 2 things.
In
In 389.
Go into the main proceedings, which is pending before the lower appellate court.
With one caveat, with great respect.
Hmm.
Under 389 now,
Yes.
under 389,
Hmm.
your lordship's will grant suspension of conviction
In
on
which
the basis
circumstance?
of prima facie case.
In
One,
which circumstance?
first is
Yes.
on a strong prima facie case.
Yes.
That's your lordship's first
And
test.
therefore, the learned first appellate court has considered your request and granted the bail.
That's on, but that's on sentence. I'm now talking of suspension of conviction only. Conviction. Under 389,
Yes.
apropos my lord's query,
Yes.
that the main appeal is pending,
Hmm.
and what test should I apply
Hmm.
for a 389 suspension of conviction? My respectful response is number 1.
Yes.
The first test for stay of conviction under 389, which will always involve the main appeal pending. Well, unless the main appeal is pending, I'll never come in a 389 to your lordships. The first test is prima facie strong case. Why is that test given? The test is given because tomorrow, Mullahs, I win my appeal. In the meanwhile, very serious adverse consequences flow, which are irreversible. So a lordship sees that is there intrinsic strength in my case. And for that, Mullahs, the ground that the very complaint could not be filed on the basis of a non-identifiable, non-suable class will be directly relevant.
Exactly.
That's the second head, Mullahs. Because if a complaint could not be filed on the basis of a non-identifiable, non-suable class, in this law, your lordship doesn't allow anybody to walk in. This is one of those clear exceptions to criminal law, as your lordship knows, lordship is handling the criminal roster, that people can, in many, many offenses, anybody can complain, or largely anybody can complain. This is one of the rare exceptions in the IPC and CRPC, which say that only a person with locus can complain, and that locus cannot be eliminated by saying that anybody of a non-identifiable massive class, group of people will constitute a complaint. That's my second head. My third head is that there are about 4 or 5 very serious ex facie. I mean, we are not asking for lordship to examine the merits, ex facie on the face of it, vitiating factors of the trial on the face of it, which raise grave apprehensions about the process of trial which led to my conviction and which are bound to succeed in my appeal, and therefore today make out a very strong prima facie case. So in prima facie case, both these last 2 points will apply.
Yes.
Serious vitiating factors of the trial. My fourth is, to separate one of those vitiating factors, namely 202, and deal with it separately, because 202, which your lordships inaugurated as a special amendment, as a special dispensation, was intended to protect from frivolous, hasty prosecutions, precisely such situations. And here, no satisfactory answer is given to your lordships, either by the learned magistrate or by the learned sessions court, as to how 202 has virtually not been dealt with, except one point, that it was raised late. Your lordship has held repeatedly, A, it is mandatory. B, if it is mandatory, it has to be a jurisdictional point. Suppose I didn't raise it at all. Even then, the judge has to apply his mind and do the inquiry. For example, limitation, to take a civil law analogy. Civil law analogy, he may not raise limitation. But if your lordship is bound to it, your lordship will see, and your lordship can suo motu and should suo motu take it up and dismiss or allow. That's the fourth aspect. The fifth aspect is that, and this is quite astonishing, the offending sentence or offending speech, absolutely no documentary evidence or no evidence, forget the word documentary, no evidence in terms of the law, in terms of the Evidence Act, in terms of the IT Act, has been produced to justify at this stage proceeding even to a conviction. To just digress for 30 seconds,
Yes.
Your lordships in a speech will have broadly 3 possibilities. Either I am the complainant, I have myself heard him saying this, so I am the witness, I depose. The second is I was not there, but my learned friend there is a reporter or a journalist who has seen it, heard it, and reported it. He can depose. A third is neither me nor reporter, but a direct person who can authenticate it. Here, your lordship will find that none of the 3 apply. Therefore, under the IT Act and under the Evidence Act, there is absolutely no proof of the offending sentence ever being uttered. Without that proof, a conviction can't lie, per se. Then, a very, very important last point would be the irreparable, irreversible nature of the consequences. Why is, at the end of the day, 389 made? 389 is made because your lordships have certain, and in this case more than any, extraordinary consequences of conviction. Now, anyway, conviction has bad consequences. I mean, one can't travel, one can't do this, that. But in the case of a public servant or a legislator, be it parliament, or it has very serious additional consequences, because such a person, suppose he misses representing his constituency
Then
for
it
some time.
is more impact duty towards the public at large. He is representing the people at large.
Yes.
He has to make his statement within limits and within bounds.
No, therefore, there is no additional liability for a public servant. Suppose a public servant makes a statement. Let me put it like this, apropos my Lord's query. Suppose otherwise, he is a not public servant, I am a public servant. Otherwise, your lordship finds that this is not defamation. Your lordship will not make it defamation because I am a public servant. That's not the law. The law is not that on the face of it, the offense is not defamation, but because a public servant has done it, therefore it becomes defamation. But that is not the point I'm making, Manas. The point I'm making is that when your lordships gives or does not give 389 suspension of conviction, my lord looks at irreversible special consequences. There is not that consequence for an ordinary person. Today, it has a consequence on myself. I stop representing. Suppose, I have missed, actually in this case, I have missed 15 days of the last session. I may miss the next session completely. So that's a consequence to yourself. The second consequence is to the constituency you represent. That constituency, the collectivity of that constituency is deprived of representation. Third, it leads to the drastic consequence of a re-election, which makes, suppose, I win my appeal after re-election is announced. How does anybody, including a court, reverse it? Can't be reversed. It's irreversible. Your lordships, fellows, have done exercise of 389, where fellows, the admitted test is it has to be a concurrent stay of conviction and a concurrent stay of sentence. Now, fellows, your lordships have, and I'll start with that point, done that exercise for very serious cases.
Yes.
Mine is a case which is neither serious nor moral turpitude. Therefore, if for sure I'm entitled to that, so let me start with that first point.
Yes.
Therefore, my first point is, please note these cases,
Yes.
and your lordship will see the consequences. In para 5 of the Sessions Court order, which is impugned, a case cited is Shyam Narayan Pandey. Your lordship will see para 5. The case cited at page 63, it is cited, lordship need not read it, just note it at 63, it is there,
Yes.
which is a Sessions. Now, what is the point I'm making as my first point? This is my first point, 1A, your lordship may call it, that the learned Sessions Court relies on these cases to deny me stay of conviction,
Yes.
to deny me. My submission is that the very same cases he relies on operate in my favor, because the test in the first 6 pages of this order your lordship is holding is that cases of seriousness and moral turpitude I should deny or should be denied. But by contrast, defamation with a maximum sentence imposed does not fall into that category. So what was the first case which is mentioned in para 5 minutes?
Yes.
That case is a case of life sentence, admittedly. Please note that it's a case of life sentence.
Yes.
Therefore, Malas, that case is a wrongful, inapposite, incorrect citation by the learned Sessions Court to deny me bail. You are, Malas, actually by contrast making out my case. By contrast, I am not a life sentence case. I am, Malas, a non-cognizable, bailable offense case. Then why do you cite this judgment? Error number 1. Error number 2, Malas, the other judgment is at page 61, para C, Navjot Sidhu.
Yes.
Navjot Sidhu was what, Malas? It was a case of 302 murder, then Malas ultimately found in 307.
Exactly.
Again, you are citing it to make the point that your case, that is the today's case, is serious enough where here this should be denied and your case therefore should be denied. So the first point is that again, Malas, is an inapposite, incorrect. By contrast, I am entitled to it. In fact, Malas, is very interesting. Sidhu with a 302 and 37 charge also got stay of conviction. He got stay of conviction. The third case, Malas, cited the third case is Ravi Kant.
Yes.
Ravi Kant is cited at para D, D for Delhi at
D
page
for
61.
Yes.
Well, this is extraordinary. It was a 376 rape case and a 366 abduction case. So the test of seriousness applies in the reverse in my favor. You are citing rape, murder, abduction cases. So you are